this episode, we will be discussing using California tenant criminal records for tenant screening. This video is brought to you by AmerUSA, where you can screen tenants 24 hours a day. Back in January of 2020, there were new regulations that went into effect in the state of California that apply to landlords that seek to use criminal history information on a prospective tenant. Let's begin by what the law says a landlord cannot use when considering an applicant for tenancy. First, any arrests that did not lead to a conviction. Second, participation in a pretrial or post-trial diversion program. Third, any record of a conviction that has been sealed by the court. And then, of course, number 4, any conviction that came from the juvenile justice system. Now, here's the really important part of this legislation. Should a landlord actually discover past criminal history on a prospective tenant and is considering issuing a denial based on that information, it must first be a past criminal conviction, and it must have a direct and specific negative bearing on a substantial, legitimate, and non-discriminatory interest or purpose of the landlord, such as either the safety of the residents, the employees of the landlord, or the property itself. The idea behind this legislation is to have the landlord look at individual circumstances that involve a conviction and decide whether it is directly related to the applicant's ability to be a good tenant. An example would be if a landlord discovered a past criminal conviction on a prospective tenant that occurred 6 years ago and it was for shoplifting. Should that have a bearing on their current application for tenancy? That is the question a landlord must answer. So it is generally advised under this law that landlords develop a policy on how they use criminal information and share that with the prospective tenant, and allow them to explain any offenses. If you would like to see more videos about being an American landlord, please like and subscribe.